Good afternoon to everyone present at today's public hearing of the Vetting Commission established under Law number 65 on the external evaluation of judges and candidates for the position of the judge of the Supreme Court. I am Andrei Bivol, I'm the chair of Panel A of the Commission, and I declare this session open. This hearing is being conducted under Law 252 on the external evaluation of judges and prosecutors, under Law 252, and under the Commission's rules of organization and functioning. As part of this evaluation process, the subject of today's hearing is Ala Malîi, a judge at the Chișinău Court of Appeal. Judge Malîi, welcome. I'm joined by the two other members of the panel. On my right is the international member Lavly Perling, and to my right is Lilian Enciu, the national member of the Commission. The panel is also assisted by members of the Secretariat. Behind you may see the representatives of the media and the public. Also present today is a photographer who will be taking briefly some photographs at the beginning of the hearing. The hearing will be conducted with interpretation between Romanian and English. Therefore, I ask everyone to speak clearly and slowly. The proceedings are being recorded. The recordings of the public hearing will generally be available online on the Commission's website within 3 days after the hearing. The closed part of the hearing will not be made available on the Commission's website, but will be recorded for and included in evaluation of file materials. During the hearing, one or more members of the panel may ask you questions. I ask you to answer them truthfully and completely. Your explanations are important to the panel in verifying your financial and ethical integrity. At the end of the hearing, you will be given an opportunity to make a brief closing statement. In posing questions, we will consider your privacy and, where required and possible, the privacy of your family members and close persons. We will leave out unnecessary details related to ID numbers, addresses of real estate, full name of some people, in order to protect your private life and the life of your relatives. Do the same. Going forward, I will start by briefly reviewing the evaluation process of Judge Malîi. The Commission initiated the evaluation on 11 April 2024 by notifying Judge Malîi by email and asking her to complete and return an ethics questionnaire and the declarations required under Law 252. Mrs. Malîi returned the completed declarations and questionnaire on 30 April 2024. As part of the evaluation of a subject's ethical and financial integrity, the Commission also obtains information from many other sources, such as National Integrity Authority, the State Tax Service, the General Inspectorate of the Border Police, other public institutions, financial institutions, and open sources. The Commission assesses the information it obtains for its relevance and reliability. On 11 September 2024, the Commission asked Judge Malîi to provide additional information by 22 September 2024 in order to clarify certain matters. On 17 September 2024, the subject, Judge Malîi, asked for a prolongation of the deadline with 7 days in order to provide the answers for the first round of questions. And her request has been accepted by the Commission. On 30 September 2024, Judge Malîi also asked for a prolongation of the deadline in order to provide answers for the first round of questions till 9 October, and that request also has been accepted. On 9 October 2024, the subject responded and provided the required information. On 29 October 2024, the Commission has sent to the Judge Malîi the second round of questions
stabilirea termenului de 10 noiembrie pentru prezentarea
with a
răspunsurilor.
clear deadline by 10 of November. On 8 November 2024, Judge Malîi asked for a prolongation with 10 days, a 10-day prolongation, which was accepted by the Commission, and the term has been extended up to 17 November. The subject responded in time and provided all the information by 17 November 2024. On 3 December 2024, the Commission asked the judge to provide additional information or the third round of questions by 12 November 2024. On 11 December 2024, Judge Malîi has asked a prolongation of the term of the deadline with 10 days. The request has been partially accepted by the Commission. The allocated time has been 16 December 2024. The subject has responded in time and provided answers by 16 December 2024. On 24 January 2025, the Commission informed Madam Malîi about the doubts in question, which needs to be discussed during the public hearing. At the same time, we have invited her to attend today's hearing. On 28 January 2025, Judge Malîi sent the Commission a request with regard to access to the information from the Commission. The Secretariat of the Commission provided this information. On 30 January 2025, Judge Malîi sent to the Commission additional information with regard to the doubts. In addition to that, on 30 January, Judge Malîi also sent to the Commission additional documentation. Judge Malîi, would you like to make any corrections or additions to the answers you have provided to the request so far? I have provided to the Commission the information with regard to the doubts received on 24 January 2025. I also have annexed some evidence obtained by me. In the meantime, other corrections are not needed at this time. Are your answers to the ethics questionnaire and the declarations that you returned to the Commission on 30 April 2024, are they still accurate as of today? They are. Members of the Commission will now ask you additional questions with regard to the doubts. We will try to keep our questions short and to the point. We ask that your answers be short and to the point as well. The member of the Commission, Madam Perling, will actually start with the round of questions.
Thank you, Mr. Chair. Good afternoon, Madam Malîi. We would like to clarify some aspects, and during the hearings, we will ask from you questions about inexplicable wealth, about conflict of interest, and about one case of ECHR case. If we talk about inexplicable wealth, we talk about years 2013, 2014, 2015, 2016, and 2023. And let's start with inexplicable wealth. Let's start with the year 2013. First of all, as you know, but during the evaluation, the Commission identified an inexplicable wealth in the total amount of minus 699,259 leis. And this misbalance was formed over 5 years. But first of all, let's talk about year 2013. And here we will talk about two issues. House, acquisition of a house, and cash savings. In 2013, your outgoing financial flows, that means expenses, appear to exceed the total incoming financial flows, income by least 113,557 lei. And now I would like to ask from you some questions. Let's talk about acquisition of a house from Durlesti. You know what I talk about, yes?
Da, sigur.
Yeah.
Am răspuns.
Of course, I have answered those questions.
Could you please explain shortly the source of funds used to cover the payment for the acquisition of a house of Durlesti? Yeah?
Pentru început, vreau să vă răspund. Centru.
I would like to point out that for 2013,
Imobil nu a fost procurat de familia mare.
I did not buy any real estate.
Procurarea casei din Durlești
With regards to the house in Durlești, I will agree to discuss that related to the 2013, but I insist that this real estate in Durlești has been bought in the year of 2014, in the month of March, and this is confirmed by the sale and purchase agreement which has been annexed. If we were to talk about
economie,
savings,
explic suplimentar.
I would like to clarify it,
Întrebări,
and I also did so during the round of questions and when I received the hearing notification. With regard to this issue, I explained in the round 1, 2, and 3, I would like to maintain that my husband, and I also presented evidence that my husband has been administering an LTD company, Girosol Aero, and I also presented evidence, and he obtained a revenue.
economie de
And
familia noastră a fost
those savings are savings made in order to buy real estate.
se mai pune dubiul comisiei deoarece se mai
I don't understand why the Commission has doubts about it, because I don't want to go ahead of things, but I would like to maintain that this company
circa 130 terenuri
had many land plots, and they alienated these real estate for 130,000 lei. And those amount of money was saved in order to buy the real estate, which was
Thank you.
which happened in 2014.
Thank you. Okay, you confirm what you have told us. Could you please repeat the amount of cash savings, what we talk about?
130
Yeah.
de economie? De economie, mă întrebați.
You are talking about savings, right?
Yeah, yeah.
131.400 lei.
131,400 lei
Yes,
obtained from the
yes, yes, yes. And
sale
this
of the LTD company.
sale of a company in 2005. Where and in which conditions you kept the cash savings?
Da? Eu am explicat și în răspuns și am explic suplimentar.
I have also explained that, but I will do it again. I saved
You can do very shortly. Yeah, yeah.
La mama mea am prezentat în
So during the round of questions,
și declarație că proprie răspunderea mea
and I also
Yes.
made that very clear in the declaration provided by my
Yes, we
mother.
know what you have answered. We know it very well. We have read. We just now want to clarify. So, as I understand, you confirm that you kept your money. That you sent the 131,400 leis for safekeeping to your mother, who lives in the village. Is it correct?
i-am păstrat la ea.
No, I kept them in the village, but not for her. I saved the money, I kept the money in that village
Deoarece
with my mother,
în casa care am locuit
because I mentioned
nu avem o securitate.
in the
Sorry, I don't understand. Maybe this is translation problem. You sent the money to your mother or no?
Da, i-am transmis.
Indeed, I sent the
Yeah.
money to my
And your
mother.
mother lived in village?
Da.
Yes, very good. And but where your mother kept this money?
Unde a păstrat
Acasă.
in her household.
In household.
La ea acasă. La domiciliu din...
That's correct. In her village, in her household.
But why? Why to send 131,000 lei to mother to the village and save the cash in the village all the years? Just very shortly explain us. Why not bank account? Why not keep the money at your home?
Pentru a nu fi utilizate în alte
In order not to use them for other purposes. We know very well that some members of the family could be using those money. Therefore, we decided to keep those money in my mother's household. And in addition to that, we thought that for security reasons, they will be better kept over there in the village, and later on we'll be using those money for a real estate purchase.
And let's move on to the year now, 2014. You say that you used this money for purchasing, for acquisition of a house.
Da.
Is it correct? Yeah. Okay.
That's correct.
One more time. Could you please tell us or explain your family's relationship with the Karchu family? Very shortly. It's not necessary to describe very.
Nicio relație.
We don't have any relationship.
De fapt,
My husband, in fact, had an interaction when they signed a contract between Madam Kociu and Beșleaga, and I have explained that issue. I don't know that person personally, never saw them.
Let's start from the very beginning.
That-
But how you found out that Mrs. Karchu is selling the property on Kartuza Street?
nu am aflat că doamna Corciu vinde.
I didn't find out that Madam Corciu is selling. I found out that Madam Beșleaga is selling that in 2014. I explained that I had a closer relationship with that family after Doamna Beșleaga bought this real estate, and she changed her mind and she left abroad and she alienated this real estate. And Madam Beșleaga proposed to our family to purchase this real estate. Therefore, we bought this real estate from Beșleaga family in 2014, and the sale and purchase agreement confirms this once again. With Kociu, we didn't have any contractual relationships. I have not met her. We bought everything from Beșleaga family in 2014. She proposed to us this transaction, this real estate.
Acceptată de familia
It was accepted by our family. It was a good price, a very good price, and therefore we could not refuse it, reject it. And we accepted.
familia noastră de procurarea acestui bun.
We decided to buy it.
A discutat, după care
My husband discussed all the issues, and we took the decision among our family's members, especially taking into account that we have those savings from earlier
But still, let's
years.
talk about Mrs. Karchu. You had the contact of Mrs. Karchu? Not at all?
nu.
Not at all? Okay.
Never.
De contractul de arbună am aflat...
With regards to the contract,
Le-ați pus în față. Încheierea contractului de arbună
so
s-a
the
datorat
the contract was signed due to relationship between the Beșleaga family and our family. My husband and I have presented actually to the Commission a power of attorney by which my husband gave all the rights provided by the law. Therefore, I did not meet that family. I didn't have any relationship with that family. It was a transaction which was concluded between Madam Beșleagă and our family. But from discussions with Madam Beșleagă, they learned about that real estate, that it is being sold.
Please, could you look the document in your screen? In 2013, as I understand, your husband paid 162,100 lei for his house paid on pledge contract.
Soțul meu nu a achitat nicio sumă.
My husband didn't pay anything. He didn't pay either 162,000. Madam Beșleagă actually paid that amount of money to Madam Cociu.
Please look at look this document. You see that this is name of your husband and this is name of a Cociu. Yes. Yes. Yeah. And the year is 2013. Yeah. Yeah. So I remind you that you said that you don't know who is Cociu, you don't have any contact, you have not any connection, and it wasn't year 2013. So how you now explain it?
I have mentioned that I didn't meet her. My husband had such an interaction with the person when they concluded the advance payment agreement. And in that day, he actually acted on behalf of Madam Beșleagă on the basis of power of attorney, because they went to the notary and they discussed those issues together, and I actually found about this contract during the rounds of questions. But if we were to talk about the fact that we concluded such a contract, indeed, when we sign this sort of contracts, the notary does not have obligation to see whether or not some transactions will actually concluded with specific money. We had the interest not to alienate this real estate to other people. So from discussions with Madam Beșleagă, there were a number of people interested to buy this real estate, and therefore my husband went to the notary and they signed the contract.
Could you please be shorter, because we just clarify. We all know all the information, just we want to clarify very shortly, please. Okay, let's go back, and you confirm now that the acquisition of a house took place 2014 and from Mrs. Beșleagă. Yeah. Is it correct? Yeah.
Yes, from Madam Beșleagă. I support this argument.
Okay. But as you said, only your husband was in contact with Mrs. Cociu, but do you know what happened between them? What happened between them, and who refused to sign the contract of sale purchase on 1st of July 2013? As you said, you saw the contract only now during the evaluation, but have you asked now what happened?
Contractul de arvună.
It's about the advance payment contract. The sale purchase agreement was signed between the two women on 30 May 2013. About my husband, he talked to Madam Cociu, and then Cociu and Beșleagă talked to each other, and they signed that contract.
Mm-hmm. And as you have shared household with your husband, you, I believe, know that your husband indicated in pledge contract that in case of refusal to buy the property, he will not claim the refund of advanced payment €10,000. Do you know about it?
Nu.
No.
No, I didn't know about this. I learned about this advance payment contract when the Commission sent me the
Okay.
rounds of questions.
As I understand, the document in front of you, you confirm that you saw the document the first time now during evaluation process.
Confirm că acest document
I confirm
l-am văzut în procesul
I've
de
seen
evaluare.
this document only in the process of evaluation.
Acest document era unul real.
And
Ulterior se
if this document was a real one and I would have known if a double advance payment would have been required.
confirmarea acestui contract verbal.
And
Acordul meu n-a fost.
there was
Eu am cunoscut
no consent on my side, for instance. There was no
furnizat întrebări.
power of attorney signed by myself.
Deja
I learned about this contract from you, and I learned that this contract was signed with a notary.
I just must ask now, what about your relationships were in 2013? Think about it, because I asked from you that the advance payment contract and the two receipts payment signed by your husband and Karču states expressly that the payment was made by Ivan to Karču on 28th of May 2013. Both were signed and the express acknowledgement of this fact was written in 3 documents. Again, this is in front of you. So, how it's possible? How you explain it?
această solicitare, de fapt, din discuțiile cu soțul a fost a doamnei
After
Garciu,
some discussions with my husband, I learned that Madame Garciu wanted
convingă că
for
o să fie efectuată tranzacția
this contract to be signed in order to make sure that there will be a successful conclusion of a contract with Madame Bleșteaga.
acordul verbal al doamnei Beșleagă de a încheia acest contract.
Okay.
Erau mai mulți cumpărători.
There were several
Doreau să
buyers,
acest bun.
and she wanted to buy this property.
Numai
The-
din acest motiv, soțul meu
This is why my husband
notarul respectiv
went to a notary in order to conclude that contract.
susțin că nu a fost
I
transmisă doamnei
maintained my position. No amount of money was given to Madame Garciu
economiile familiei
from the family's savings on or from other sources that
Okay.
we had back then.
Let's move on and let's. Or would you like to talk about? No. Yeah, please.
Doamna Malîi,
Madame Malîi,
eu înțeleg următorul lucru.
I understand the
Soțul
following.
dumneavoastră
Your
a
husband
ajutat un prieten.
helped
Așa
a
rezultă
friend.
din declarația dumneavoastră.
This is what
Aici.
is clear
Deci,
from
dumneavoastră,
your
el,
statements.
domnul Malîi, a
Mr.
mers în locul
Malîi
doamnei Garciu, în
went
locul
in
doamnei
stand
Beșleagă
of
și a
Madame
semnat
Bleșteaga
doamna Garciu
and signed with
arvuna
Madame
respectivă.
Garciu
Deci,
that
dumneavoastră nu
advance
contestați
payment contract.
valabilitatea
You do
semnăturilor,
not
Asta
contest
este chestionat,
the
pur și simplu el a semnat în locul ei.
validity of
Acum, întrebarea
the
este,
validity of this. Yes,
Dumneavoastră spuneți că asta era nevoie de asta.
and you said
ca
it was
doamna
needed
Garciu
to be
să
done
nu vândă
to make sure that
proprietatea
Madame
altor
Garciu
potențiali
doesn't
cumpărători.
sell the property
Acum,
to
întrebarea
other
mea,
potential buyers. Yes.
logică ar fi,
The
dar
logical
dacă
question
nu s-a achitat
here
niciun-
is,
nu s-a achitat nimic,
if
ce
nothing
valoare
was
are
paid,
această arvună?
what is the
Pentru că
value of this
Înțeleg eu
advance
că în cazul în care
payment?
se refuză
I understand that
cumpărătorul,
when a buyer
vânzătorul oricum nu a
refuses,
primit nimic. Nu
the
a primit o arvună.
seller
De asta cumva
receives nothing
noi
in this
încercăm
case.
să înțelegem
They did not
care
receive
era
an
logica
advance
să semnezi o arvună
payment. So
fără ca
what was
vânzătorul să
the
primească
rationale
nimic.
behind signing this
ce fel de
contract of
garanție e asta
advance
dacă
payment if
cumpărătorul nu pierde
no
nimic
advance
dacă
payment
refuză de
was
fapt?
made and the buyer did not lose anything?
a fost achitată această sumă.
Așa.
The second day that amount was paid. It's from the words and declarations of Madame Garciu and my husband.
And as I understand, if we talk about 2014, and we talk about 2014, we talked about cash savings, and you confirm that you used the cash savings that to buy the house. Is it correct?
Corect.
It's correct.
Okay. And that's all. No other sources.
Din veniturile familiei pentru
The income of the family from that year, besides those savings.
If we talk about 2014 and you used the cash savings, could you please tell us what kind of sources of income you used to purchase in this year the car, Volkswagen Transporter?
In 2014.
Yeah.
Am folosit economiile familiei
I used the family's savings
din anii precedenți.
from previous years.
Afară de economie respectivă
Besides
menționată
the
cu 131
saving
miliei,
mentioned above, 131,000 lei, my family had other savings as well, and I mentioned in my answers to a round of questions
văzut și le-ați citit
this, and I'm sure that you read the answers, according to which
din perioada căsătoriei, din 97 și până mai apoi
since
din pensionar, am
97
strenat bunuri mobile.
my husband
Procurate
had
celelalte
real
economii
estate.
obținute
So
de soțul meu.
the real estate bought, or the assets bought, originated from the income of my husband and the cars that were sold over time. It's a regular practice in Moldova. Its cars represent a hobby of my husband, and from this hobby he also gained some money.
Yeah.
Sumele bănești obținute din
So
venitul
to buy the car, we used salary income plus
acumulate surse bănești.
real
Do
estate
you
properties
confirm
sold.
that all the cash savings were declared? Yeah.
Confirm.
Okay.
I confirm.
Very good. Let's move on. Let's move on. 2015. Now you have used your savings. You have used your cash. Let's talk about Chevrolet Captiva. Please, just very shortly again. 2015. Explain us, please, the source of funds used to cover the payment for the acquisition of a car model Chevrolet Captiva. Very shortly, just name the source of funds.
Vânzarea pentru 2015 Chevrolet Captiva a fost procurat din
Chevrolet Captiva
economia
was bought in
de
2015
casă,
from
vânzarea automobilului,
savings, family savings, and from
alte bunuri mobile, Hyundai Santa Fe și alte bunuri.
selling Hyundai Santa Fe, a previous car, and other assets our
Okay.
family owned.
And what about the seller of this car? Did you know the seller of this car,
Da,
Karimenci? And how you knew?
ăsta era un prieten de
It
soțul meu.
was a friend of my husband's.
Separație, însă dumnealui este decedat.
Okay.
Unfortunately, he passed away.
Okay. Then you can explain again shortly, but why would the seller give you discount about 50% of the market value of this car?
Am explicat acest dubiu.
I explained this doubt. I clarified this doubt to the commission. My husband received an offer
De la prietenul respectiv,
from his friend
a efectuat și a
above
oferit
mentioned,
servicii pro bono.
and then provided pro bono services, repair services.
Are succes. Și a oferit mai multe automobile care au fost.
And it was successful, and in the case of several cars, this was the practice. It's as per my husband's statements. Unfortunately, he's no longer alive, so I cannot confirm this.
Okay, let's talk about 2016. Here we see that your ongoing financial flows appears to exceed the total incoming financial flows by at least minus 119,461 leis. And here we should talk about now cash savings. Could you please explain? We already know that you had bought a house and you had used your cash savings, Could you please explain the sources of funds used to cover the declared cash savings in 2016?
I believe that for 2016, there's actually a positive balance. Because at the end of the year, in the assets declaration, I declared 135,000 lei as savings. It was declared for a reason, in order to be in line with Law 133. This amount was given me for safekeeping. Subsequently, in 2016, it was given back to the owner, Madam Beșleacă.
Okay.
This was a saving that I had to declare. Only for this, I included it in the rounds of the questions, because it is also in my declaration of assets and personal interests submitted to NIA.
But could you again very shortly explain why you now took to keep the money of Lyudmila Belzhega, if previously you just explained that you sent your cash savings to village to your mother?
This amount, well, those savings were for 2013, 2014. They were used in 2014 to buy the real estate. The savings declared in 2016 belonged to Madam Beșleacă, and it was declared in the assets declaration in order to be in line with the legal provisions, namely Law 133, that stipulates that all the savings should be declared. And I wouldn't like to speak about my private life.
It's not necessary. Just tell us that why you didn't disclose this information to the Commission in the first round of question?
I didn't deem it necessary. I didn't perceive it. Otherwise, it was a saving included in the assets declaration. It was in the documents submitted to NIA, and it was a savings. If you requested explanations in the first round of questions, I would have provided.
Thank you. As you said that it's always necessary to declare the savings, and now let's finally, and then we can finish inexplicable wealth issue, talk about 2023. 2023. And we know that in your explanation provided to Commission on 30th of January, you explained that the source of the funds to purchase the car model Ford EcoSport comes from the sale of a car model Mazda 6 in 2022. And now the question is, could you please explain why you didn't declare the savings in your annual declaration submitted to NIA 2022?
I declared to NIA the alienation of this car, Mazda 6, which shows that I respected the annual declaration provisions. That car was bought from the sale, the previous sale, and the first car was sold with 160,000, and the second one bought with 164,000. 4,000.
Okay, you say that you declare the car, and that means that you thought that it's not necessary to declare cash savings. Okay. I don't have more question about inexplicable wealth. Maybe my colleagues have, or we can move on and talk about conflict of interest. No. Okay. Let's take next topic number 2, conflict of interest with Irina Silvestro. So first of all, again, very shortly, but we could have some kind of frames. How would you define your relationships with Irina Silvestro?
cunoscuți suntem.
We are acquaintances.
Meu,
My husband
anterior,
worked previously
soțul doamnei,
with her husband
instituție de stat.
at a state institution.
Cunoscut și noi suntem
They met each other there. We are acquaintances.
Okay, but acquaintances can be very different kind of acquaintances. Some acquaintances you say just hello. With another acquaintances you spend time together. You can go to trips together. What kind of acquaintance she was for you?
Dacă să vă referiți la deplasarea care am
If you refer to the trip,
scop de tratament,
it was for a purpose of treatment, not for leisure purposes. I presented this answer in a round of questions. I crossed the border together with this family, and you included the evidence. Yes, I crossed the border, and only once it was for treatment purposes. We are acquaintances. I cannot give them a different qualification or status. They are not relatives or friends. They are acquaintances. My husband knew her husband.
Okay, that means, okay, we understand, but it's more than hello acquaintance. As I understand, you confirm that according to information of system between 2022 and 2024, you have been actually rapporteur in 7 cases in which Irina Silvestru participates as an insolvency administrator. And all cases concern insolvency proceedings. You confirm it, yeah? Yeah,
Yes,
thank you very
I
much.
confirm.
Thank you very much. And could you please explain which legal provision you provides that the insolvency administrator is not participant in this proceeding? Because it was your explanation. Just say us legal provision and that's enough, because I believe you have prepared now.
articolul 55,
Article 55 and 59 from the Civil Procedure Code.
prevederile
Moreover,
ceea ce m-a implicat pe mine și am explicat că doamna este
I
participant
explained
în caz,
that
este
she
o
was
doctrină în
a
acest
participant.
sens, am explicat în răspunsul la întrebări.
I explained the situation in the answers about a party and the definition of a participant and the difference between the two.
So, but
Do I need to
still,
give additional explanations?
how would you comment when Article 4 of insolvency law, which, as I understand, provides that the insolvency administrator is considered a participant in insolvency proceedings? Is it, in your opinion, contradiction, or how you explain it?
În articolul 4 este indicat
In Article 4, it says clearly participant, but according to the doctrine, participants are divided into 2 categories: participants with proceedings interest and those who have also material interests. These are debtors and creditors.
sunt administratorul de insolvență.
But there are also participants with no interest in the case, the insolvency administrator in this case, that are working in public interest.
Okay, but according to paragraph 10.2 of the Supreme Court of Justice explanatory decision in the application of insolvency law, is not allowed the appointment of an administrator closely related to or dependent on the charge. I read the text from here. So, what is your opinion? Do you think this prohibition would be necessary for non-participant in the proceedings?
Eu am explicat și
I
susțin
explained and support
nu a fost participant pe cazurile
continuously that Madame Silvester was not a participant in these proceedings. Moreover, you mentioned that I was a rapporteur. I wasn't a rapporteur in many of these cases. But taking into account the Commission's doubt, and in order to avoid or eliminate these doubts, I sent 2 self-recusal applications
declarații de abținere
that I submitted and are still being examined. They were annexed to the material sent to the Commission, and the Court of Appeal denied to accept these self-recusal requests. I continue to support that Madam Silvestru was not a participant. We have the doctrine, we have the Civil Procedure Code that stipulates clearly who is a participant and who is not, and whose financial interests are being
Thank you.
protected.
But in your additional explanations of 30th of January 2025, you informed the Commission that finally, that following the notification of a hearing, that you recused yourself now in 2 cases, and they were dismissed by decisions of 28th and 30th of January. Now you made self-recusal. Could you please explain why you recused yourself in the cases if you consider that the administrator is not a participant in the proceedings?
I have mentioned, in order to rule out any doubts on the part of the Commission, and subsequently not to have additional doubts from other participants in the process. However, I do believe that the judge needs to act impartially, irrespective of any situation.
Okay, and the last question about this topic, but did you recuse also in the 3rd case, which was only attributed to you, Lux Magister?
So we had two cases.
Okay, you can answer about both. And you know the case what I talk about.
So we are talking about the cases which were not examined,
actually. The question is very simple. Before you didn't self-recused yourself, now during the evaluation you self-recused yourself. My question is, what about now, the very last case, Lux Magister case, did you recuse yourself or no?
Let me remember. So I recused myself in 2 cases which are under my supervision. Those who were examined in the previous years when I wasn't a rapporteur, I didn't recuse myself. I only recused myself in cases I was handling. I didn't self-recuse because in cases where there was an incident with regard to procedure.
So it's okay if you say you don't remember. Maybe my colleagues have questions about conflict of interest. Yeah.
Madam Malîi, I would like to go back to the last question. Do you have the notification of doubts in front of you? Could you please open the page number 34, the version in Romanian language, please? Yes, I have it. So on this page we have a table with these cases. Do you recognize them? I do. So we've got 7 cases here in which we are talking about insolvency cases or that result from insolvency cases where Madam Silvestru is indicated as a administrator for insolvency. Now you have made a clear distinction between cases where you've been acting as a rapporteur and in cases which were pending and the ones were examined. Could you please look onto this table and tell us in which cases you recused yourself? So we are talking about Prihozhanin and Ruski Group, 6. What about 7? The 7 has been examined, and I have mentioned that it was examined in 2021. In that period, the administrator of that company was Ruslan Vasilyev. So when I examined that case, Madam Silvestru wasn't at the helm of this company. So let us go back to the case number 6, 5 and 6. In these both cases, you presented a recusal, self-recusal, and those declarations have been filed following initiation. Now I understand that those declarations have been rejected because the appeals court, the Center's appeal court, have not identified the circumstances needed to do so. Now, I've got a question, a general question, because when it comes to other cases when you didn't self-recused, I heard and I saw in your answers the doctrine, the distinction between the part in the process. And my question is, you have not self-recused due to the fact there is this clear distinction, and you didn't consider that in principle there might be a conflict in interests, either due to the nature of relationship that you didn't consider sufficiently important in order to self-recuse. It's both of them. It was actually due to the nature and due to the fact that she wasn't part of it. In both cases, I thought that I should not self-recuse. I didn't have any relationship with that person in order to self-recuse in this respective sense when it comes to the Article 50 of the Civil Procedure Code. Thank you. Let us stick to this table since we are on this table and maybe point out something interesting. When it comes to the case number 1, was Silvestru present in the hearing room? She wasn't present there. First of all, I wasn't a rapporteur in that case. These cases are being examined with the participants being absent from this room. We are not report who is the administrator of a specific company or the other company. We do a brief report on the case, and then the panel takes the decision with regard to this case. I didn't even know that this part is actually acting as a administrator of this company. But when you familiarize yourselves with the material of this case, being member of the panel, have you mentioned, or have you noticed the last name of that person? I'm talking about prior to the hearing. If well, provided I was a rapporteur, I would have made sure that I familiarized myself with the material of the case. Besides that, there was a request to review due to the fact that the people in the process could not be present during the hearing. But for the next position, 2, 3, and 4, according to the list, was the respective person present? All those litigations have been examined without participant being present during the hearing, during the process. All the otherwise are the incidents related to the proper procedures. I'm talking about Magister Luke's 2 cases, number 3 and number 4. Those are incidents related to procedure with regards to replacing or moving the case from one court to another court. And those are being examined without the participants being present in the room, in the hearing room. If you remember, throughout your professional experience, but also in your private life, in your everyday life. Maybe you have interacted somehow with Madame Sylvester. Do you remember that? We do see that you traveled together at some point. Maybe she took part in some family events. We didn't participate, or maybe some... No, she didn't take part in any family events. Thank you. A last question. You said that Madame Sylvester did not take part in person in front of you. She did not plead it in front of you, and all the decisions were taken without the participants being present in the room. So we've got 7 cases, right? In one of these cases, was Madame Sylvester present in the room, pleaded in front of you? Was she? In one of the cases, when we had another person representing the case, lawyer McAvey. And then I found out that administrator of that company was Madame Sylvester. In one of the cases, did you participate as assigning Madame Sylvester as an administrator for this case? Never.
Thank you. And the last issue. This is the ECHR case. And this case concerns the finding of a journalist and an association liable for defamation following the publication of an article about funds received by individuals close to the Socialist Party. And we talk about the article, alleged financial ties between the Russian-linked offshore company and a Moldovan company with close connection to Igor Dodon. And the article detailed the transfer of 1.3 million euros from the offshore entity to Moldovan company and its subsequent distribution to individuals linked to the Socialist Party. Yes. In this case, you participated as a judge of a Court of Appeal. Do you agree? Yeah.
Correct.
Yeah, and which by its decision of 18th of April 2018 dismissed the applicant's appeal. And the court appeal ruled that the article was defamatory and ordered the applicants to publish retraction admitting that their claims about the alleged foreign financing of a Socialist Party and Mr. Dodon's campaign had been untrue. And now the ECHR later found that the national courts had failed to conduct a proper balancing exercise and ruled that there had been a violation of Article 10. And you already explained and you mentioned in your answer that the Court of Appeal didn't have much enough appreciation and respected the imperative rules of law. And my question is, could you please explain now to which mandatory rule did you refer?
I refer to the law number 64 from 2010, and I have motivated that this decision has been reasoned based on the case law of European Court of Human Rights, and I also applied. We have also applied the provisions of the European Court, and we explained that that was part of that valuable judgments with factological extract with very opinionated substance. We took into account the case law of European Court of Human Rights. I have in front of me the decision of Appeals Court that confirms once again that that decision has been reasoned. And I would like to highlight once again that in solving this case, we didn't have a discretions with with regard to the incident of the case, and all the findings of European Court of Human Rights and the conviction of the Republic of Moldova happened due to the review of this decision that found out that the reviewing body didn't provide proper substance and didn't recognize the article from convention. However, after the review of this case by the government decision, actually they rejected the case. And the Article 10 has not been respected, and we didn't pay the damages provided by Article 41 from the convention. And those findings are being expressly mentioned in the decision.
Okay, but in this article were a lot of links to the sources and so on, but my question is that considering the article and the evidence provided by the journalist, how did you determine that the statements were defamatory or false? How?
In this case, the plaintiff had to prove that this qualification actually is strong enough not to damage the honor and dignity based on the Article 24, Article 2 from the Law 64, obliges actually the plaintiff to confirm that these judgments is based on a factological material which has not been proved. Therefore, out of this consideration, the college applied the legal provisions in force.
Yes, but I understand. But as we know, that the article is based on evidence. But you publish that this is false. And my question is that how did you determine that the statements were defamatory or false? How? This is article, links, documents, sources, and how you control that this is false?
Because we had an excessive opinion, unexplained this thing, and it was reasoned by the decision of the court, where I have maintained that it was an excessive opinion in this particular case. The facts based on some documents should have been evidenced by the plaintiffs, because they would have been sufficient so that later on the appeals court could reach another decision than the one issued previously in 2011. In order to prove that information, and this fact has not been evidence, the college decided it was an excessive opinion. Therefore, based on this reasoning, we motivated this solution based on the European Court of Human Rights case law. I pointed out these moments expressly in the paragraphs of the decision.
And my last question is very simple. If you did the decision, did you feel some kind of pressure to do the decision, or it was your absolutely free will by independent judge?
I have never witnessed any pressures when taking decisions. The decision was taken based on the national legislation in force.
Thank you. Thank you, Madam Malîi. No more questions from my side.
I do have a question. You have mentioned previously that in this particular case you have applied the rules with regard to the evidence provided based on the freedom of expression.
lege, în articolul
This law in the
24,
Article 24
repartizează cumva sarcina probației.
states very clearly
Ambele părți trebuie să
the
demonstreze
burden
ceva,
of
nu doar
proof.
reclamant, nu
Both
doar
sides
păretul.
need to prove something, not only the
De
plaintiff.
exemplu, legea dată
For
articolul
example,
24
this
spune
Article
că- spune
24
că
states
reclamantul trebuie să
that the
demonstreze
plaintiff need
următoarele.
to demonstrate the
Fără corespundentă
following,
informație,
that
că informația îl
the
vizează și este defăimătoare,
defendant
că informația este
has
relatată cu privire la fapt și
spreaded
este în
false
esență falsă,
information and the
sau
information
judecata de
is
valoare
not
nu se
true,
bazează pe un substrat
and
faptologic suficient.
there is no sufficient
existența
evidence in this
cuantumului
respect,
cauzal.
and the damage inflicted
Părâtul trebuie să
in this case.
dovedească
So
că informația nu este defăimătoare
the defendant
sau nu
should
vizează pe
prove that
reclamant.
this information is
informația
not
este
defamatory,
judecată de
and
valoare
this
care se bazează
information
pe un
is a
substrat
judgment
faptologic
which is
suficient.
based on evidence,
Că la momentul
sufficient
răspândirii
evidence, and at the
informației
moment
deși a luat
of distribution of
toate
these
măsurile de
materials,
diligență, nu
all
putea ști
diligent
că prin
measures were
acțiunile sale
taken, and
contribuie la
he could
răspândirea
not
relatelor
was
false
not
cu privire
aware
la
that he
fapte sau
was
judecăților de valoare,
distributing false
fără substrat
statements
faptologic
without
suficient.
any substantive
informația
evidence, and
răspândită este de
therefore the
interes public.
distributed information
Acum,
is
întrebarea mea este dacă
is of public interest.
completul din care a
Now,
făcut
my
parte a
question
făcut
is,
această,
was the panel
analiză în care
involved in this
stabilească
case,
că, cumva,
did the
fără
panel involved in
echivoc,
this case conducted this sort of
și-a
analysis
exercitat
and
sarcina
established
probațiunii,
that
iar
the
părâtul nu și-a exercitat sarcina probațiunii.
there was a burden of proof? Indeed, all those issues have been reasoned with details.
Mulțumesc.
Thank you.
No.
I would like to know whether during the examination of this particular case, the representative of the defendant administered some evidence, or he refused to do so, or he didn't have any evidence. Could you please explain how that happened and what were the circumstances that were taken as the basis in order to provide or to support the arguments?
If I look at the decision, it's clear what the defendant has presented in court. If I look at the file, I would see the proof and the evidence provided. But in the decision, you can see the arguments of the defendant in the first instance court and in the Court of Appeal. And the reasons were presented in that decision. I don't remember, I don't recall the materials. I was not a rapporteur on that case, but I was a member of that panel. You actually anticipated the second question of mine. The decision of the Court of Appeal has been challenged and examined by the Supreme Court of Justice. Yes, it was declared inadmissible. The request of appeal is submitted by the Reporters Association.
Doamnă judecător Malîi, completul a epuizat toate întrebările care le-a avut față de
Malîi,
dumneavoastră.
the panel
doriți să faceți o
exhausted
declarație
all the
scurtă de
questions
final?
it has had for you. Do you want to make a brief statement? Yes, I want and hope that I will have an evaluation that is correct, brief,
Și noi vă
and
mulțumim.
will be in line with the
Am ajuns la
national
sfârșitul
legislation.
acestei
Thank you.
audieri.
Thank you.
Doamnă Malîi, vă mulțumim
We have
pentru
come to the end
prezență,
of
pentru
today's
răspunsurile
hearing.
oferite în
Madam
timpul
Malîi, thank you
evaluării în formă
for the
scrisă
information
și
provided
răspunsurile,
and
care
answers
le-ați
to the
prezentat
questions
astăzi în fața comisiei. După
provided
audierii,
today
completul va
before the
aproba
Commission. After the
un
hearing, the
raport de
panel will
evaluare
approve
care
an
va conține
evaluation
concluziile,
report stating its
privința
conclusions
corespunderii cu
as to whether
criteriile de
or not the
integritate
subject
etică și
meets
financiară
the criteria
prevăzute
for
în legea
ethical and
52.
financial integrity under Law
Raportul de evaluare va
252.
fi întocmit și aprobat în
The
cel mai scurt
evaluation
timp posibil.
report
Mulțumesc.
will be
Declar
approved
ședința închisă.
as soon as possible. I declare this